Hi, folks, and welcome to White Collar Week. It's the isolation that destroys us. The solution is in community. On the podcast today, we have Richard Lee. Richard is best known for having been a trader at Steve Cohen's hedge fund, SAC Capital, and for having insider trading charges against him dismissed after a 7-year fight to clear his name. Richard initially pleaded guilty to insider trading charges in 2013, and upon discovery of new evidence in 2017, he moved to withdraw his original plea. On June 21, 2019, a federal court judge for the Southern District of New York granted Richard's motion to vacate his plea. And then on November 27, 2019, federal prosecutors dismissed all charges against him. I first met Richard in 2013, soon after he first pleaded guilty. We've been friends and have worked together closely ever since. On the podcast today, Richard and I discussed the entire story that led to his incredible outcome. So coming up, Richard Lee, insider trading charges dismissed on White Collar Week. I hope you'll join us. Hello, and welcome to White Collar Week, a podcast sponsored by Progressive Prison Ministries, the world's first ministry serving the white-collar justice community. I'm Jeff Grant, co-founder and your host. I served almost 14 months in a federal prison for a white-collar crime I committed when I was a lawyer, so I know that it's the isolation that kills us, and the solution is in community. So let's get started. Hi, folks, and welcome to White Collar Week. We have a very special podcast today. One of my old friends already. Richard and I have known each other for over 7 years. This is Richard Lee, and he's well known because of his case in a hedge fund case that was brought by Preet Bharara in the Southern District of New York, and it was dismissed. And that's a rare thing that happens, certainly in the prosecution world, and especially in insider trading cases. So Richard's going to talk all about that. We're going to divide this podcast into multiple sections. The first is basically going to be an introduction and bio and some information about the case itself. The second is going to be more generalized about the hedge fund industry and specifically what folks misunderstand, a little bit about SAC Capital, where Richard worked, and maybe some of the other places. And then the third part is going to be lessons learned, and there are a lot of lessons that Richard learned and that we learned together throughout this, and notably about attorney selection and what to do when you're in trauma, especially when you first get arrested. And so structurally, this is a little bit different than the way that we usually do things on the podcast, but I think it's the appropriate structure for this particular podcast. So let me say hello to Richard.
Hi, John.
And this is Richard Lee. Richard, so welcome to White Collar Week, and welcome to everybody. I'm so happy to have you here.
Well, thank you very much, Jeff, and thank you for your friendship over the years. It has been about a year since the case was dismissed. And I think with some perspective, I'm able to speak about it with more clarity and more reflection. So I really welcome the opportunity to talk about what I went through, what I've learned, and most importantly, the lessons learned for folks that might find themselves in a similar situation. And I think also for folks who are taking a look at this period of time in history, comparing it to the SNL scandal or comparing it to the .com bust, and trying to make some sense as to what was happening at that time. Mm-hmm. So I'm looking forward to it.
Or might be happening soon with SBA and PPP litigation. So there's no question that this was a unique period of time.
Absolutely.
That you experienced, and I know how hard it was for you and your family. So why don't we go right into your kind of introduction and your bio.
Okay.
And then into the case itself. And there's no question that this is going to be 95% you and 5% me. So why don't you go for it?
Sure, absolutely. So my name is Richard Lee. I'm a former portfolio manager at SAC Capital. And SAC Capital was indicted in 2013. It was a relatively famous case. And the firm pled guilty. The firm then closed down, and a new firm was opened, or the old firm in some sense was opened under a new name called Point 72. It was a pretty well-known case at the time. I worked at SAC for about 2.5 years. Before that, I had worked at a number of other hedge funds, and I had worked for a couple of years for the Clinton Foundation, which was a nonprofit. And I started my career, I went to college at Brown University, and I started my career working in consulting at McKinsey. So that's my career background. I would say, and maybe we can get into this at a later date, but the trajectory of the hedge fund industry from the time that I had joined up until the time of the prosecution of SAC, really changed. And it was something that I was, I guess, fortunate to partake in or witness. But I think it's important to talk about when we discuss sort of the business ethics of the industry and the information gathering practices, and ultimately how it became a target for prosecutors. I guess probably the most pertinent place to start would be how my case started in terms of how I was targeted by the government. And I guess one thing to point out would be, it was about 2008 or 2009 when the government, through the FBI, started approaching hedge fund traders, trying to coax them into cooperating with the government's investigation. And ultimately, this all exploded into a series of prosecutions that began in the fall of 2009. And at that time, there was an explosive article that was published in the Wall Street Journal at that time about, the government engaged in investigating, what they called a vast insider trading conspiracy across hedge funds. And this is something that, I witnessed from my seat at SAC Capital, seeing folks, some of whom I was acquainted with, and most who I didn't know, getting arrested left and right. And they did, in fact, arrest a couple of my former colleagues at SAC Capital. And it continued to unfold over the next 2, 3, 4 years, up until March of 2013. So at this point, this is, fully in the, fully in front of Wall Street. People widely speculate that the U.S. Attorney for the Southern District of New York is targeting my former boss, Steve Cohen. Mm-hmm. And a number of people, in my firm have already been charged and or pled guilty, and or I don't believe anyone had been taken to trial yet at that point. So when I was walking home in March of 2013, and it was actually my second to last day at SAC. They were closing the Chicago office, and I was thinking about other things that I could do with my life. I think I was 32 or 33 at the time. I was walking home, and 2 FBI agents approached me in front of a Macy's on State Street here in Chicago. They asked me who I was, and then they played a tape for me, which I couldn't really hear at all. But they asserted that I had committed insider trading. I had no memory of this conversation that I had had with a Wall Street sell-side research analyst 4 years prior. And I think it's important to note that they were playing something for me which had occurred so long ago that I really didn't remember it. And that's what sort of began a whirlwind of anxiety and just a crazy experience that resulted in myself pleading guilty to securities fraud, to insider trading.
So, Richard, just to be clear, they played you a recording of things that had happened far in the past. So mm-hmm. When you say you didn't remember it, it's you conducted a lot of business. There were a lot of different transactions you did, obviously as a trader. So there'd be no reason for you to remember specifically what they played for you at that time.
That's right. When people talk about insider trading, and if they've seen the movie Wall Street with Charlie Sheen, they talk about getting illicit information from lawyers that are on transaction teams, or from investment bankers, or from company insiders. This was an entirely different discussion. This was a discussion with a sell-side research analyst whose job it is to talk to clients all day long, distribute published research to clients. And the reason why this call was recorded was not because anyone was being wiretapped. It was because there was an execution trader, somebody who takes buy and sell orders from the client, on the call. And it was a call that their own compliance had recorded and then provided to the SEC in the fall of 2012, I think principally in light of the fact that they were trying to overturn every stone related to SAC Capital and see if they could find something. So that's, I think, what makes this a little bit different than how people would ordinarily think of when they think of insider trading. It was by all accounts, sort of a run-of-the-mill type conversation that somebody in my shoes would have with 7 or 8 different folks every single day.
So we'll continue.
Okay, sure, absolutely. So from that period of time, and I believe this is March 28th of 2013, that's sort of what caused this domino effect of, and the only way I can really frame it at this point is this sort of insane rationalization and this emotional journey that I went through where I was frantically trying to find an attorney to represent me. I was effectively Googling and cold calling white-collar defense attorneys, people's names I would read in stories, and I would call their attorney who was listed on the story to see if they could represent me. And it turned out that half of the attorneys were already conflicted at that time, and for whatever reason, I ended up selecting an attorney, my first attorney, so to speak, who then led me through the process where I began to cooperate with the government. And cooperation really, at that point, meant just going in and having interviews with the government and taking their questions, up to this point where it basically seemed that I had no choice other than to plead to this thing that I had no memory of, in which I felt that I was strongly innocent of. And it culminated, sort of in me reading this allocution that had been written by my attorney in front of a judge in July of that year, in sort of a secret proceeding. And then, a few days later, that plea being unsealed concurrent with the indictment of SAC. They're sort of frosting with the cherry on top from the U.S. Attorney's perspective, because not only were they, indicting SAC, but here's another guilty plea, the 7th person, I believe, at the time that was either indicted or pled to charges from SAC Capital. So, and that process itself.
So Richard, before you move forward, so you must have had a series or a lot of conversations with your lawyer at the time, and that led up to your proffers, or that led up to ultimately to a guilty plea. And what was that like?
Yeah, I mean, Jeff, it's really, from my standpoint today, I in some respects, we're not so tragic. I sort of marvel over my state of mind at that point. After the FBI approached me, there was a series of subsequent sort of sleepless nights, and it's something that I try to explain to people. But when something like this happens, I personally felt just terrible about my life, and not that I was guilty of what I was being accused of, but just how could something like this be happening? Mm-hmm. Was it a kind of retribution for not doing more public service earlier in my life, that I had been blessed in so many ways, and that's something I really feel is the case. And maybe I should have been doing more volunteer work, or maybe with great privilege comes great responsibility, and maybe I had been eschewing that in some respects. So when I began to select attorneys, there were a couple of key things that I would say key misconceptions that I had made. The first was that it was impressed upon me that it was important to select a defense attorney who had been a former prosecutor in that office, the Southern District of New York. And for whatever reason, I had that notion stuck in my mind and would only look at defense attorneys that had that. And I think the logic is that, these are their former colleagues, and so if they come in and they make an assertion for their client's innocence, that carries more weight because it's a person that they know. In reality, I don't believe that that's the case. I don't believe that having a defense attorney who's a former prosecutor helps at all. And in fact, in some respects, it could actually hurt. And we can get into that at a later point.
Sure.
What had happened at that point effectively was the government, they sort of, I don't want to say it was a purposeful trap, but they basically dangle something called cooperation, which is, if you come in and you cooperate and you talk with us, ultimately, if you plead guilty, every single person, and this is actually factually true, every single person who had been given a cooperation agreement by the government did not go to prison, save 2 people, and those 2 had extenuating circumstances. So the argument was, go in and talk to them. What do you have to lose? And in the worst case, all you're doing is sort of buying insurance because nothing will happen at that point. In practice, what actually occurred was that these discussions were not about a fact-finding mission on behalf of the government. These discussions were sort of predicated on trying to induce the target, that is me, to give leverage to the government. And it could be leverage not in terms of admission of criminal guilt, but it could be leverage in terms of character, arguments that they could use regarding character, anything that they could help them with respect to putting you on trial. And there becomes a sentiment, and this was certainly my feeling, was once you begin to cooperate, you're past the point of no return. You've already started to tell them about you have to be completely honest, and you have to be completely forthright about anything that can be used against you. So you really just have to come to them with sort of open arms with respect to all of your conduct, not just relating to this insider trading case, but anything that you might have ever done in life that could be used by a defense attorney on cross-examination, whether you stole a candy bar or any number of these types of things. You're expected to really come forth and disclose all of this to them.
So Richard, making sure that we're not jumping ahead to the lessons learned section so fast, but there's no question that at that time you're in trauma, you're vulnerable. They know it. You probably don't know it, but your attorney knows it or should know it, and there you are, pretty much prey to whatever their agenda is, and there's no way that you understand what's in your own personal best interest.
I think that's exactly right. The reality is, it's the circumstances of the situation that one is in. You're more or less told when you are the target of a criminal investigation, you can't talk about your case with anyone except your attorneys and your wife. So this life-changing event that I'm going through, I didn't have anybody to rely upon other than my wife, who is not American and really was just scared throughout this period of time. I had a 6-month-old daughter at home who I did not want to leave, and then I had attorneys. And when I talk about attorneys, defense attorneys who were former prosecutors, what they carry with them is much of the cynicism and much of the, I would say much of the cynicism of being a former prosecutor, and the view that at times, when the government begins to target you, they already have you, there's a term, dead to rights, in terms of the case. So, many defense attorneys, and in fact, this is the case, one I did not pick, immediately started talking about a guilty plea and cooperation without even discussing whether or not, the merits of my belief very strongly at that time that I was innocent. That was a pretty remarkable defense attorney I interviewed. So, there is a lot of bias that pervades the defense attorney's mind in terms of the way that they're advising you. And, I think at that time, I was just so out of my mind that I didn't want to have to make a decision. I didn't want to have to make these choices. So I surrendered sort of my agency, in a sense, to attorneys. And attorneys are advisors. Attorneys cannot tell you what to do. And I think that's probably something that I did not stress enough in my mind. I probably even wasn't aware of it. I think I basically said, look, guys, just what do I do here? Just tell me what to do. And I think that was, obviously in hindsight, it's 2020, it was a tragic mistake.
And just because we've had a long relationship since, and because you're a regular on our white collar support group that meets weekly, that abdication of control to attorneys is a huge issue that people often regret later. And one of the things that I know that you became aware of later is that you're really a cog in a very large machine, that the attorneys have these relationships with the prosecutors, and they're looking to maintain a certain level of overall relationship with prosecutors because they have case after case after case. And I don't want to go so far as to make the claim that every attorney is not looking out for their client's best interests, that particular client's best interests, but it's at least theoretically possible that any particular attorney at any given time might be looking to take care of his entire network, his entire fleet of cases, and not the decisions that are made aren't necessarily for that client's particular best interest. So how do you feel about that? I mean, do you think that played in part of this?
I mean, look, Jeff, I think you hit the nail on the head. The reality is, and look, I was in a money manager, right? We always look at people's incentives. The reality is any one client for a defense attorney, unless it's a corporation, is transactional in nature, right? And unfortunately, in many people's cases, their life is on the verge of being utterly destroyed in a way where there is no repeat business from an individual criminal defense client. So, if I were a defense attorney, right, what do I care about? I care about the ecosystem that I have, the good relationship I have with the prosecution and the judge and my peers in the space. And obviously, I have this idea of my fiduciary duty to my clients. But the reality is, look, my experience was that, there is advice and then there is telling somebody what to do. And there is a line that bifurcates the two. And maybe this is hindsight, but, I feel that what I did very poorly was to surrender my agency to the attorney. And to some extent, and I think it's a very fine line for most attorneys, because it would be, if I were one, is to understand where you stop in terms of here is how I see the case. And, I'm sorry, you're asking me to, what you want, what to do, but it's actually your choice to make. And I want to believe that that's, I think that's a very, very fine line to navigate as a defense attorney as well.
Well, I'm a former attorney,
right,
and a former general counsel to closely held companies, and I was always clear with my clients that basically they're the gas and I'm the brakes. Yes. They call me up to hear the no, to hear what the problems are going to be or what not to do, but I don't make business decisions. You have to make the business decisions. I just have to point out what the pitfalls are or what the potential issues are.
Yeah. No, that's right.
All right. So please continue.
Okay. I'm sorry. I think we were talking about the cooperation process. And
yes.
What I was describing was, what begins as a series of interviews with the government, I think quickly becomes into a series of interviews about giving them leverage. And then at that point, you're sort of beyond the point of no return. Mm-hmm. They have you. And the conversation then changes from, everybody who has cooperation, everybody who's come in to speak with us, none of them have gone to prison, into now you have cooperation. You've got to actually give us something. But in my case, and I think it was something that became readily apparent to them, they had hoped that I would have all of this incriminating evidence about Steve Cohen or about SAC Capital. And we can talk about it later, which is, what do I think people misunderstand about SAC Capital and the series of insider trading cases, but I didn't have anything to give them. I had very, very little to give them. And it was impressed upon me, you need to try to think of something, you need to try to come up with things that are going to please them. And I racked my brain. And ultimately, there was a competitor for a job at SAC Capital when I was hired who badmouthed myself and a colleague. I told them about that. And a number of these stories, which I had provided to them, were then taken out of context and used not only in the criminal indictment against SAC Capital, but ultimately against me. So, it's a very interesting process. That cooperation began in a certain way and it ended up being something completely different. One thing I will say is that, at the end of the day, when I ultimately pled guilty, the inducement to plead guilty was really, we are giving you cooperation. And that's a formal legal issue. The government will write what is called it's called a 5K1.1 letter, which is a downward departure from sentencing guidelines, such that the judge, it's a signal to the judge to not give prison to such a person. And I think something to note is, the government would like to frame cooperation as somebody throwing themselves at their mercy. Here, I'm trying to help you, and please show leniency on me. Write this letter for me. But that wasn't my experience at all, right? My experience was plead guilty, and we, as an inducement to do so, we will give you this cooperation agreement. Substantively, cooperation typically means things like wiretapping others, testifying against others, but none of that happened in my case. I'm too much of a nervous Nelly. There was nobody to actually wiretap. And I think that they understood substantively that 5K1 would not contain material assistance because I had none to give. So I just think that that's a dynamic about the cooperation and about the 5K1 that is sort of important to understand. It can be used and it can be framed as, somebody came in and tried to help the government and did things like wiretap others, et cetera, and really, threw themselves at the mercy of government to give them leniency. But at the same time, it can be, you're so scared of being indicted, come and plead guilty, and in exchange, we'll give you this cooperation agreement. And that latter was, candidly, was my experience. So, and I think ultimately, had I not had that, I would not have pled guilty. But ultimately, that was what my attorneys deemed was the best option for me. And I want to say around July 21st or July 22nd of that year, I pled guilty.
So what was the case itself that they actually brought against you, or that they told you that they were going to bring against you, and then how did that wind up springing into the actual case and the actual guilty plea?
Absolutely. The case was effectively the tape. And the tape was myself having a conversation with a sell-side analyst, which analyzed solely by itself doesn't look great, right? He's talking about a friend of his at Microsoft who is saying that they're seeing people from Yahoo on campus, and that it was his feeling that a partnership announcement, which had been widely speculated for 1.5 years prior to that date, because Microsoft at one point had made an offer to purchase Yahoo, that a partnership announcement was imminent and might happen in 2 weeks. And in fact, it did happen, and it was announced in 2 weeks. And the sequence of events on their face would don't look great. It was not something that I had remembered, and my attorneys felt that the tape would be, quote unquote, hard to beat in a trial. My feeling at that time was, this is a sell-side analyst, and it was in fact the first time I had ever spoken to him, right? So this was not some special favor that he was giving to a friend of his or a long-term client. It was something that I had felt that he was telling everyone, and that rendered it public information. And again, it wasn't a call at 6 a.m. or 5 a.m. in the morning. That it was, I was, last in a long line of clients with whom he probably had a better relationship with versus somebody he had never spoken to before.
And that was his job, to speak to people like you all day long, right?
That's right. So, and that was the constant protest that I had made, to my defense attorneys. In fact, that at a prior employer, we had specific compliance training that would suggest that I believed that this was a permissible conversation. But for whatever reason, there was no interest in actually going back to the former employer to try to pull up the compliance training notes. I think just terrified. I was terrified of being arrested publicly and having a perp walk.
Sure.
I don't know how to explain it, but I just couldn't imagine and couldn't bear the idea of my parents seeing that. Mm-hmm. And that loomed very large in my head. So, at the time that I pled, we were, and my attorneys believed that it would be quiet and that this was the best way to sort of, quote unquote, save face with respect to what was happening. That pleading guilty was infinitely preferable to a public arrest. And that was sort of how I calculated it in my mind. Or how
so two things. A lot of, especially academics and researchers, when they're talking to me, what they want to know is, what are the sociological precipitating factors that go into people committing white collar crime? And I'm not trying to jump ahead here, but you mentioned your parents, and I know that you had a specific background being Korean American, and so why don't you talk about that a little bit, and then I want to move from there to the research that was or wasn't done into the activity that was surrounding the day in question.
Oh, right.
And
sure.
So, because I think that's a very important part of the story. So why don't we cover those two bases?
Sure, absolutely. So, look, if people ask me, I consider myself thoroughly sort of quote unquote American. I was born and raised in the western suburbs of Chicago, but I do have very traditional Korean immigrant parents who, they met while they were both pursuing their doctorates here in, I think at Northern Illinois University, and they were academics, right? So growing up, I had academic parents, and they stressed this for myself and for my older brother. The reality is, there's a lot of aspects of Korean culture that are part of me, which is, I don't seek to put myself out there necessarily. And I think that's sort of an Asian American trait. I pride myself on work. I pride myself on achievement and education. I think that there is certainly a stereotype of people who work on Wall Street as these models and bottles, money flashing type guys. And actually, my parents are very buttoned down folks, and I consider myself as such. I believe I went and worked on Wall Street solely out of a sense of achievement. And had I worked in a different field, I would have measured that achievement differently. But with respect to pleading guilty, I never told my parents about the case until the day or the 2 days before I went to plead guilty. And that was a mistake. One, it's understandable one doesn't want to worry their parents. Two, I wasn't sure of how it would ultimately turn out. And three, there was this sense of shame that I wanted to really avoid. And so the decision to plead guilty, I can't stress enough, again, is in my mind, I felt that what I thought would have been a quiet guilty plea was preferable to a public arrest. And that is something which is completely incorrect, and yet somehow was a notion that was very much in my mind at the time.
It's hard not to jump ahead to the lessons learned part of this too much. But one of the things that you and I discussed early on and wound up being a theme that we kept coming back to was how much of a defense budget should actually be spent on forensics, should be spent on uncovering the actual facts themselves.
Mhm.
And certainly, you know that my position is that um, lawyers, like any other business people, they take a good chunk of the defense budget,
Mhm.
but before you go in and speak to the government, it certainly would be helpful to know what evidence there is and what the context is, and so tell me what happened there,
Uh-huh.
and how you might have done things differently. Again, we don't have to jump to the last section first, really lessons
Right.
learned section, but ultimately, your case is very well known, Richard. So there were facts that didn't come to light in your case for years.
That's right.
Had you known in advance, would have led you to make a very different decision.
Yes, that's right. And thank you for mentioning that, because I had forgotten to mention it. The most important, when you work at an investment firm, right? You have instant messages with traders and with other members of your team. You have emails, um, and these are critically important business records that you should have a chance to review before you decide to plead guilty to something that you feel that you didn't do. In my case, we never had access, the government either, to my emails or to my instant messages that would have, where I might have been talking about this call I had with the sell-side analyst, or where I might have been giving trade orders and instructions to our trader. And in hindsight, that's ludicrous. How could you plead guilty without having some of the primary facts that you need in order to ascertain whether you actually are culpable or not? Yet in my case, the most important thing was, and I believe that this was probably driven by the way that the theatrics of how the government wanted to proceed. They did not want to subpoena my records from SAC because they were concerned that if they subpoenaed them, SAC would know that I was a target and would reach out to me. Simultaneously, they told me, you cannot approach SAC for help. So, and this is something that I deeply regret. I funded the attorneys out of my own pocket, which, look, candidly, if you have a corporate budget to spend on defense, you're much less parsimonious with respect to the things that, to the activities that you're undergoing. Although at my time, pretty much the lawyers were driving the bus, and I asked no questions with respect to what they decided to spend time on. And so, that very much affected the outcome. The inability to talk to SAC meant that I wouldn't have advantage of SAC potentially indemnifying me. And most importantly, I didn't have access to the primary details. So, it's something, obviously, that it was a major mistake made in hindsight. I obviously had provisional discussions with my attorneys about, what a defense might cost, but those ranges were so wide that, and I think realistically, when somebody is put in this type of situation, they are vastly deprioritizing the legal budget because they're just concerned about what's going to happen. And that was certainly my mindset at the time. Things obviously changed many years later when I sought a second opinion on what had occurred.
So you're a trader by profession, and you're used to doing research, looking at source documents,
Yes.
Sorting through them, trying to find details that other people might not see.
Right.
But you're in massive trauma at the time. Do you think that there's a part of you that adopted the government story, that they told you something happened and that shaded the way your thinking was about it, and so you felt a sense of guilt, that and coerced guilt, and therefore it may have made you less less interested. Not interested is the wrong word, probably, but not when your attorneys didn't want or didn't suggest reviewing those source documents prior to you doing your proffers or prior to pleading, it didn't kind of go off as an alarm bell. Something's wrong here.
That's exactly right. I had an initial view, which is very easy to assert at this point, which that I thought that was a permissible conversation, but the tape itself, which was taken out of context, was something that my lawyers felt was black and white, and this constant sort of I don't want to say combative, but this constant friction back and forth regarding this made me question maybe my entire moral compass is just miscalibrated, and all of these things that I thought were okay and legal and legitimate actually are not. And in fact, maybe I just need to surrender my sense as to what was right and wrong and my mens rea or state of mind to what my attorneys and the prosecutors are saying. And I actually there's a lot of details that I could probably mention with respect to that, but that was absolutely an element of what occurred. And I certainly believe that's one of the reasons why my wife also felt that there was no choice but to plead. That maybe I was just in a different universe, and these things that I thought were completely okay, I was just wrong about.
So are we jumping now to the fact that you've now pled, mm-hmm. and you have remorse, you have regret almost immediately?
That's exactly right. So, if we want to talk about, let's say, the fallout from what occurred, mm-hmm. It was exactly the opposite of what my attorneys and I originally had thought. It wasn't a quiet guilty plea. It was, there was a media blitz about it. There were a number of articles that appeared in all the major newspapers about it. And I immediately realized I had made a tragic mistake. One of the things that I was particularly upset about was that there was I mentioned briefly that the circumstances where I was hired by Steve Cohen, where a former colleague of mine from a former employer really resorted to sort of slander and rumors in order to try to get hired himself instead of myself and a colleague of mine. And in sort of the media blitz following my guilty plea, I think the former employer wanted to distance itself as much as possible from what had occurred, and would feed stories to the media that were factually untrue. In many respects, some of those stories, and I still believe this, and I asserted it at the time, were much worse than the insider trading plea, because it suggested a type of impropriety that, at least from my sense and my sense of morals, is actually really bad. So it was just terrible. And the reality was, as much as I wanted to quote unquote fight back or even have discussions with these journalists before the articles were published, my attorneys told me, you can't do this because you're now under a cooperation from the government, and anything you try to do to correct something that looks bad about you or fix anything will be seen as antagonistic by the government, because they want you to look as slimy as possible to enhance their own case against SAC. So it was a kind of terrible sense of helplessness and despair that I was overcome with. I really can't stress that enough. I want to say probably within 1 or 2 months after entering the guilty plea, I went back to New York to discuss potentially withdrawing my guilty plea, and I met with another attorney, and she was a former prosecutor as well. She was very impressive. She said, the first thing she said to me was, it's a shame you didn't come here because we don't plead our clients. But the most important thing she said, and I think what, sort of, I want to say, was reflective of the kind of cynicism I mentioned that prosecutors might have. Mm-hmm. She said to me, look, I understand that you feel that your plea was coerced, that you're actually innocent. And some of the facts that you're presenting to me, I can understand exactly why, and maybe you are. But the reality is, some of these things that you're complaining about with respect to a coerced plea, lies through omission by the government, these things you may be surprised by, but I am not. when I was a prosecutor, I did these types of things. This is just what happens. Most people don't understand that. And with that, my head hanging low, I left her office and returned home feeling that there was nothing I could do. And gosh, I just have to live with this terrible mistake that I had made. So,
that's about the time you called me.
It's actually precedes when I called you. So I remember actually when I called you because I was using a rented Regis office here in River North in Chicago. And I believe that there were continuing CNBC stories about SAC. It may have been around the time that SAC itself had pled, which was a couple of months later. But I turned off the lights in the room. I was feeling lost. I didn't know who to talk with. And there was an article that was about you. I think it was in Institutional Investor magazine.
I think Absolute Return Hedge Fund. I can't remember the name of the magazine. Absolute Return.
Okay, got it. And I just, again, in the same way I Googled and found my original attorneys, I Googled you and I found you, and you replied, I believe, really fast, within a half an hour, and we had our first conversation at that point. And your friendship and sort of shepherding me through the subsequent years, and I think withdrawing my plea at a later date and preparing for what seemed to be trial at that time was just invaluable in terms of keeping my head on straight, because the subsequent 7 years was just an emotional roller coaster with respect to the possibilities, what I should do, a number of friends and family just asking me to move on, and this happened and you need to just move on with your life. So it's around that time that we met. It was around that time that I was actively exploring, whether I could withdraw my plea.
Right.
And it seemed like there was nothing that could be done.
Well, one of the things we talked about once we kind of got you back on your feet, because you were in pretty rough shape at that point.
Sure, yeah.
But once we got you back on your feet, was that the government and the media's perception of SAC Capital, Steve Cohen, and their compliance was really all wrong.
I think that's when we talk about what I think people misunderstand about SAC, that's certainly one of them. Maybe I don't know if you want to jump into that section now. We can certainly do so.
Sure.
Okay, great. Look, there's a number of books that have been written about this. There's a number of books that have been written about SAC. I had a former colleague named Matthew Martoma who was indicted, taken to trial, and found guilty in what is called the largest insider trade in history. I think $276 million. Even I've taken part in some business school interviews where their subject reading matter is a book that was written about Matthew Martoma and SAC Capital, and it's called Black Edge. My feeling very much is that that book is entirely wrong, and I can maybe I can start and I can talk a little bit in terms of a retrospective about my time in the hedge fund industry.
Sure.
When I started in the hedge fund industry in about 2002 and 2003, I was a research analyst at a very large and well-respected firm back then, and it's still to this day. And at that time, nobody knew what a hedge fund was. It was preceding a time of explosive growth and interest in hedge funds, which occurred in 2005. I joined as a research analyst. I built financial models. I interviewed. I did, channel checks and research. And at that time, there was a company called Gerson Lehrman Group that was offering connecting experts or insiders at companies with hedge funds that wanted to learn about those companies. And we utilized Gerson Lehrman Group, or GLG, extensively to try to learn about the unit economics of semiconductors, NAND, flash, and a number of other industries. At this time, I think people knew very clearly what was inappropriate information, right? Information that you get from a lawyer, information that you get from a banker. This is wrong. And I think that everybody understood that. When you're starting to talk about company insiders who have visibility into trends that the ordinary public might not have access to, this is starting to get into a gray area. And it was a practice that we actually were very proud of. When I say the practice, we used a job research site at that time called monster.com to find people inside companies. And again, this was not to seek inappropriate information. It was to get employees' perspectives of the management team. Were they ethical? Were they conscientious? Were they penny pinchers with respect to the way they thought about growth? And we would use this extensively, and we thought that it was brilliant research. We thought we were on the cutting edge with respect to the way that we were able to get insights into people and companies and understand how the businesses worked better than the next guy. Gerson Lehrman Group took it to the next level. And I remember very clearly when I was at this firm, I had a interview with a company insider at an electronics distributor. And I always ended my interviews, is there anything I haven't asked you about that others have, or things that, we should know about? And he said to me, many people ask me what our quarterly earnings are going to be next quarter, but I don't typically get those until about a week beforehand. So why don't you give me a call back a week beforehand, and we can set up another paid interview, and I'll tell you. And at this point, that's clearly wrong. And I immediately called our compliance department. Who
just to be clear, this was at a firm that you were at prior to SAC Capital.
Prior to SAC.
Okay.
I like to cite this example because this conversation caused our compliance to be extremely upset. They called the expert network firm, Gerson Lehrman Group, and they instituted a change which impacted all of their clients, which was that compliance would be aware of and emailed simultaneously when all of these interviews were being set up, so that their compliance could nix the interview if they wanted to. Mm-hmm. The only reason I describe this is because I want to describe the atmosphere of hedge funds at that time in terms of what was considered novel research and what was actually looked favorably upon as good research. I then moved on to another firm in the 2007 to 2008 period. And at this point, the hedge fund industry has exploded in size. And a common practice at that firm was to actually talk with investment bankers about trends that they see in M&A. And look, I was never part of a discussion which crossed the lines at all. But, that's a very, very, this type of conversation does not happen today. And because of the size and influence of the firm that I was at, we felt, gosh, this is how we're getting better insights than the next guy, because we are so large that investment banks and brokerages are willing to set up calls with their bankers to give us a better understanding about what the M&A landscape looks like, or what divestitures look like, or what management teams are thinking about. Because M&A happens in waves. One deal goes off, and then management teams all begin to think that they have to do a deal, et cetera. And they can give us insight into how management teams are thinking as a whole. Okay, now we fast forward to SAC, right? So we have the backdrop of the expert network phenomena, which began when I started in the industry. We have conversations with investment bankers that were practices at prior firms that I worked at. And when I entered SAC, one thing to keep in mind is that SAC had such great performance over the preceding 2 decades. Everybody felt, and I think this is natural in a space where alpha is a zero-sum game. Mm-hmm. Alpha means sort of outperformance over the index. It's not like technology innovation or startups where it's a rising tide that can lift all boats. In the hedge fund space, if you're doing well in terms of alpha, by definition, that means somebody else is underperforming. And that, I want to say, infects the mindset of how people think about competitors greatly. A lot of people felt that maybe there's something untoward happening at SAC because his numbers are so great. And obviously, I can't speak to or speculate about that at all, right? Because it precedes the time that I was there. But when I joined, their compliance team and their compliance department was exponentially tighter than any of the other firms I had worked at. Certainly, we could not speak to company insiders. Certainly, speaking to investment bankers was out of the question. And moreover, there was an active surveillance of emails and IMs, an active surveillance of the investment portfolio, trying to understand, if a company in a portfolio, was acquired or there was any large one-day change, a postmortem in terms of understanding what had happened and what did you know. So, from that perspective, was it overcompensation because SAC was trying to correct for either, what I would consider an unwarranted perception in industry? Maybe. But, when we get to the point where SAC itself is being prosecuted, and look, a lot of good people lost their jobs in the prosecution and indictment and guilty plea of SAC Capital. I firmly believe a lot of that is unwarranted because the practices at SAC were at another level relative to some of the other very large and prestigious firms I had worked at that time. And I'm sure what has happened, subsequent to that is that every firm on Wall Street has changed their practices in terms of what is permissible. I certainly don't think that those things are happening today, but I just feel that when people want to flag and target SAC as a firm that was a bad actor in the space, where a term that Preet Bharara used was a magnet for market cheaters. I mean, my experience was the exact opposite. It was a decentralized firm where the necessity of having a diligent and vigilant compliance was absolutely necessary, and they did a good job of it. So
Richard, so this is like a Peter Drucker culture view, where you're a button-down guy, that's a button-down firm, and the culture there at the time you're there is compliance heavy, very buttoned down, even if in some people's mind it's cowboys and Indians, but that's not what your experience was. And so you must have been very comfortable given your background and your need for that kind of structure. You were that kind of guy.
I'm sorry, the video froze for a second. Yeah, I mean, look, the value proposition that SAC offered to people when they were bringing them on board was, you are effectively running your own firm within our firm. Mm-hmm. You have the infrastructure of the compliance and the back office that we can offer you, but we give you basically the freedom and flexibility with respect to practice your investment philosophy and your strategy the way that you want to, without the hassle of running the actual business in the background, from the back office, the marketing, the compliance, and so on and so forth. So from that perspective, that was the value proposition that Steve offered, and that's how he would try to attract people who were considering setting up their own firm or going to work for him. Mm-hmm. It had nothing to do with, in my opinion, with attracting people who were playing close to the line at all. Mm-hmm. And I firmly believe that was sort of a fiction that was invented. I mean, it was a necessary invention to try to indict the firm. Yeah.
So now we're in the 7 years that you're in the wilderness.
Well, actually, before we jump to that, if we're going to talk about, things that I think people misunderstand about the firm SAC Capital, I would also like to talk a little bit about what I believe people misunderstand about the insider trading prosecutions overall.
That's great.
Is an important topic. Coming out of the financial crisis, there was a lot of I want to say there was a public need for retribution, a desire to see some type of rights to correct the wrongs that people feel intuitively must have been committed. The financial crisis was terrible. You had Occupy Wall Street, which came up in the years following the financial crisis. I actually, went down to not participate necessarily, but to observe, because I was so. And there were elements of that I actually completely sympathized with, to be totally honest. What had happened was that there were two phases in my mind with respect to the insider trading prosecutions. And this is something that folks who are actually studying it should probably try to understand. The first is that there was a wave of prosecutions linked to that Wall Street Journal article in the fall of 2009, which were Rajat Ratnam at the Galleon Group, Rajat Gupta, the former CEO of McKinsey, a gentleman named Zvi Goffer. And these were insider trading cases that were more or less black and white, open and shut cases. Lawyers were being paid off. Company insiders were being paid off, and there was money exchanging hands. These cases were all initiated under Preet Bharara's predecessor in the SDNY, former US Attorney Garcia, who was at the tail end of the George W. Bush administration. Those investigations were initiated, and in some respects, and this is my phrasing, were handed to Bharara on a silver platter at the time that he began his tenure as U.S. Attorney.
Sure.
Those prosecutions, were not. I don't believe they were overturned. They were pretty clear cut, and they most importantly won Preet Bharara a lot of media attention. I think he was put on the cover of a magazine. This man is cracking down on Wall Street, and there was a sense, in some respects, oh, we're finally getting retribution for the financial crisis because here are these financial actors that Bharara is jailing. In reality, the financial crisis was caused by mortgage fraud, which was being propagated along a chain from inception to packaging to distribution to investors. Insider trading had almost nothing to do with it. But it's my belief that Preet Bharara felt, gosh, I'm getting so much media acclaim from this, and people think that I'm doing something about Wall Street. Let's have more of it. And at that point, a number of cases were initiated and brought, many of which, and I think, gosh, if you had to take a look at the second half, a large percentage were overturned, including Chieson and Newman, which became a major case, which is clarified insider trading law.
Sure.
Michael Steinberg, a former colleague of mine, my case, and a number of others. So, what I think people misunderstand about this time in history is that, one, the insider trading cases were brought in some respects to try to satiate the public's need for some sense of corrective action following the financial crisis. But in reality, no corrective action was ever taken. And this is purely from my knowledge of some people who worked in subprime mortgage packaging. I don't even think they necessarily looked, right? You have a banker who is soliciting mortgages that he knows to be fraudulent, and then he packages them up, securitizes them, and slices and dices and sells them to investors knowing this. I actually happen to know some of these individuals, and they've gone on to, they actually went on to firms that invested in the fallout from the financial crisis and did very well for themselves. But the reality is, I think one, the good cases in insider trading were actually initiated by his predecessor. The bad cases were ones that he started himself. And I think moreover, nothing was actually done to address the root causes of the financial crisis, which arguably lays a foundation for something worse coming down the line.
Yeah.
Nobody can know with respect to that. And I just think that's something that I think is important to realize.
But there was also a perception that the insider trading cases were low-hanging fruit, easy to prosecute, and that might have been true in the beginning, but we know that later on the cases were much more nuanced. There was a lot more going on there than the those early cases, and you lived through a lot of that of that change.
That's right. I mean, one of the reasons why it was such a roller coaster following the guilty plea is that I believe in the fall of that year, the Newman Chieson case was overturned by the Court of Appeals,
right.
Demanding that there was a requirement which was proving personal benefit, which had not been provided by the government in those cases. And that began basically a sort of a kickball back and forth, where the U.S. Attorney Preet Bharara then filed for an appeal on that case, and filed for cert actually to the Supreme Court on that case. And the fallout from that case, which clarified the laws of insider trading, not only overturned a number of guilty pleas that they had procured, but just changed the overall landscape for prosecutions and added an element of another element of proof that the prosecutors needed. In my case, this accrued to my benefit because all of these Newman and Chiasson provisions applied to my case. And I want to say a couple of years following the guilty plea, a number of attorneys, defense attorneys that I had spoken with, were advising me urgently to try to withdraw my plea, citing Newman and Chiasson as the reason for doing so. But I was very reluctant to do so because I wanted to make an assertion for my innocence that I was thoroughly innocent, that I never felt that what I was doing was inappropriate. And that was the struggle that I had had with defense attorneys back and forth regarding that. I ultimately switched attorneys from my prior attorneys to an attorney named Greg Morvillo, who is in some respects my savior because one, he was receptive to taking a case that was very challenging because of the guilty plea. And two, he crafted an argument that was predicated both on the Newman and Chiasson decision, which was there was an absence of personal benefit in my case, but also, as we went through the process, he crafted an argument which asserted that I was factually innocent. And that gets to sort of the evidentiary standpoint, which we discovered in 2017, which I can get to if now's the right time.
Oh yeah, I think it is, except that when you went, because you and I spoke a lot at that around that time, Greg Morvillo came onto your radar because he had had some success at that point.
That's right. Greg Morvillo is an attorney that I would not have considered under the prior notions that I had when I was first searching for an attorney in 2013, because somehow somebody told me that I needed an attorney who was a former prosecutor. Greg Morvillo himself was never a former prosecutor. He has been a practicing criminal defense attorney his entire life. And that accrued to my benefit because I think he was actually willing to understand and listen to the story with his experience, but without the taint of a kind of cynicism I think that develops over time from a prosecutor's perspective, that everyone is guilty and they're just either delusional or hiding something. So when I first met with Greg, it was to get a second opinion on my case solely with respect to Newman and Chiasson. And he felt strongly that I could make a motion to withdraw my plea based on that. But some time had passed, and then there were a number of other court cases, one called Salman, that came before the government, and it further clarified Newman and Chiasson to an ambiguous benefit for myself. And here's the calculus that we had to really consider. I was owed a cooperation agreement by the government. Most certainly, when I went to sentencing, it was very likely that I wouldn't go I wouldn't have prison time, but I would have a felony and I would have to live with, the consequences of my decisions for the rest of my life. If I made a motion to try to withdraw the plea, I would blow up the cooperation agreement. Yes. So even if the judge decided, I'm not going to vacate your plea, I would not have the benefit of the cooperation agreement at the time of sentencing, and I would likely go away for some period of time. That's a very difficult decision to make. And
sure.
That's something my wife and I struggled with greatly. I think she would have preferred at that time for me to just go to sentencing, get the cooperation agreement, and move on with our lives. I couldn't really bear that.
And certainly at the time, you understood that the passage of time, the lengthy passage of time, was not to your advantage in trying to withdraw a plea.
Correct.
I know that weighed heavily in terms of the likelihood of the judge even entertaining whether or not you could withdraw your plea.
That's exactly right. I think most people familiar with criminal defense law understand that it's almost impossible to get to withdraw a plea from a judge. because there's a sense of finality with respect to a guilty plea. It's almost impossible to do so. Mm. And we concluded that it would be difficult as well. And facing the consequence of losing the cooperation agreement and being sentenced to prison, because that was the most likely, in fact, the 90% plus chance most likely outcome, we decided, look, it's just best to just get this behind you. So we agreed to go to sentencing at the beginning of 2017, upon advice of Morvillo and working through the permutation and the potential bad outcomes. We agreed to go to sentencing. And as a part of that, we needed to finally get data about when the trades had been entered with relative to the time of the conversation I had with this sell-side analyst. And in the process of collecting that data, we discovered that I put in the trades, in fact, 97% of the trades, before I even spoke to the sell-side analyst.
All right, so let's be clear about what you're saying.
Okay.
So, one, this data was available the entire time. Whether or not you had access is another story, but this is the source data. This is the raw data.
Yes.
And two, you had been told a different story by the government as to the timing of this, of what happened.
Yes, that's right. So I cannot assert that the government deceived me, because I don't believe that the government deceived me. The government just made an assumption which was incorrect. I believe that the government had the date of the conversation I had with this analyst, and they had the number of shares that were traded on that date. And they assumed that I made those trades after I spoke to him. In reality, I'd been trading all that week. And as we later come to realize, I actually traded before I spoke to him, which cannot be insider trading, because that's not how insider trading works. So, it's a bit shocking. Look, after we found out this information, I went to my mother and I explained this to her, and she just had this stupefied look. And you didn't know this when you pled, type of look, like,
your mother, who's an immigration attorney, by the way. So let's just be
clear. She's not a criminal. Sorry, she's an immigration attorney, but she's not a criminal defense attorney. But she,
exactly.
She's an academic, and she can do logic, and she was just stupefied. And honestly, it's absurd that I didn't know this at the time that I had pled. So, we got a couple of pieces of information from the government at the time, and which were that I traded before I even spoke to the guy, and that's sort of, you can't commit insider trading if that's the case. And when we approached the government, their stance was, I think, one, maybe understandable from a prosecutor's perspective, which is the guy pled, like, what do you expect us to do?
Sure.
Right. And 3% of the trades were entered after he spoke to the guy. Right. So, arguably that's still insider trading. And we said, come on, guys, like, he obviously didn't make anything of this conversation. If he thought it was pertinent, this just doesn't make any sense. It doesn't fit any normal sense of insider trading theory whatsoever. But it was a high profile case. It was linked to SAC. I think much of the office's sense of pride and even institutional ego was wrapped up in it. Mm-hmm. So, they were going to fight every step of the way. And at that point, we said, look, I said to Greg Morvillo, and he agreed, I can't, in good conscience, go to sentencing at this point, knowing that factually we have data that shows that I traded before I even spoke to the guy. On top of that, I never thought I was doing anything wrong to begin with. And we crafted a motion to withdraw the plea, which was two-part. One was on Newman and Chiesa, on the absence of personal benefit. And the second was that I was actually factually innocent upon this new evidence. And we did that knowing that the cooperation agreement would likely be blown up. And should I fail, I would be going to prison.
You'd have what is commonly called a trial penalty. If you went to trial, you would be sentenced to a much much longer prison sentence than had you cooperated or had you pled.
Correct. And moreover, actually, not just the trial penalty, but there was a sense that the prosecutors could try to punish me above and beyond that.
Right.
Because from their perspective, they would say, how dare this guy that we gave this cooperation agreement to, again, their perspective that we are showing mercy and leniency to, try to withdraw his plea. We need to make an example of him. And there was that element of as well, which we could not quantify, which loomed large. Should I be unsuccessful, it's not just the trial penalty, but the desire for vengeance, in a sense, from the prosecutor's office that could make my situation that much worse.
So when did you make the motion to withdraw? How long did it take to get resolution or disposition of that motion? And what was going on in between? I know the answers to these questions already, but you didn't know whether or not you were going to get a motion decision, you were going to get sentenced. You didn't know if the judge was going to rule on the motion at the sentencing. There were actual times when you thought you were going to have to come to New York to get sentenced, but it got delayed. Why don't you just describe all that?
Sure, absolutely. So, upon discovery of the new evidence, we moved super fast. Greg Morvillo, and to his credit, felt that it had been 4 years since I had pled, and if we are going to make an assertion that new evidence was factually proving my innocence, we have to move very, very quickly. So within a couple of months, we filed a motion with the court that we were going to withdraw the plea, and we filed the motion to vacate the plea. And the government filed its customary objections. The guy pled, come on, give me a break here. And then it sat with the judge. And just because of the peculiarities of the judge that I had, and I want to actually say one of the reasons why we had the conviction to submit the motion was because we drew a judge who was not regarded as being defense-friendly at all, but a judge that was widely considered to be a legal nerd, a judge that will write 20 pages on an opinion when 2 would suffice. And so I trusted that this judge would seek through, understand the details, and that would accrue to my benefit. One thing he did was, instead of adjourning my sentencing date indefinitely, he just kept on moving it 2 months at a time or
Right.
3 months at a time. And we didn't know how to read into that. There came a point where we felt that he's going to deny the motion, and we need to prepare for sentencing. And as you know, there's a lot involved in preparing for sentencing. So I went to a number of former colleagues to get favorable opinions. Asking if they would write something nice of me, basically.
Sure.
That might move the judge towards leniency.
Mm-hmm.
And we went through this entire process. We went through meeting with the probation office to get guidelines in terms of what they would recommend for sentencing terms. And then the sentencing date got delayed again. And I want to say, it was probably delayed 8-9 times until the summer of 2019, just a little over a year ago, where, abruptly one morning, Greg Morvillo called me and emailed me, and he said, look, the judge vacated the plea. It was a miracle. It was, it was a miracle, but, there was a sense of foreboding, which is, okay, now, what comes next? Likely a trial.
Sure. Be careful what you wish for. Now you might have a trial that you're staring at, and you got what you wanted, but things could get bad in a hurry.
Absolutely. So, the judge, and just to be clear for folks, the judge vacated the plea, not because what he said about my assertion of innocence was, this is an argument that I don't deny, but it doesn't fully prove your innocence. Rather, we are vacating the plea because your plea was insufficient based on the Newman and Chies, on the knowledge of personal benefit.
Right.
I think that's important to note because it speaks to Greg Morvillo's skill. He understood that a two-part approach would be best versus basically screaming, I was always innocent to begin with. Look at this. It must have been a coerced plea, which candidly is sort of the route that I wanted to go. So, I think that speaks to his excellent work as an attorney. After that, the government made every motion to make it appear as that we were going to trial. I went to New York on a couple of occasions. The government stated that they were ready and prepared to trial. And this is the fascinating period of time for me, because we are finally getting discovery from the government. We are finally getting emails and instant messages relating to that time that the trade took place. Additionally, we're getting transcripts of interviews that they had taken of other people involved, the supposed tipper, the sell-side analyst that involved, with respect to sort of understanding what had happened. And I remember in amazement looking at these notes and this data and asking Greg, how are we going to go to trial? I mean, how are they going to mount a case? Because everything here not only is to our benefit in a soft way, but in a hard way. Every single person here is denying that there was any exchange of inside information that took place. The trades, more of them took place before I even spoke to him than we realized to begin with. We have evidence from 7, 8 other people who were receiving the same phone call from him, so, credibly raising the question as to whether the information was already public to begin with. So it was a very strange time. We were preparing for trial. We were very fearful that the simple defense of the government or argument the government would make would be, why does somebody plead guilty to something that they didn't do? Which is just, but then, miraculously, I want to say, a couple of months later, the government began to approach my attorney and ask, if we were to offer a deferred prosecution agreement, what would your guy say? And we rejected that. We rejected any notion of making any admission. We had not gone this distance to basically have a deferred prosecution where there was an implicit admission of guilt to something that I firmly believe I hadn't done. And I remember even at that point, people were like, "Are you crazy? Like, would you? You're crazy to say no to a deferred prosecution agreement." But we did, and then the government came back and said, we're willing to just enter something called a nolle prosequi, which is Latin for dropping the case altogether as if nothing had ever happened.
Exactly.
And they did that, and I believe that was the beginning of November, about a year ago.
Mm-hmm. I remember when you called me, and it hadn't been signed yet.
Right. That's right.
I think there was a day, probably. I think it was one day. And you said, this is what happened. And we were in shock, but it still had to be signed.
Yes, that's right.
And so we were sworn, everyone was sworn to secrecy pending the execution the next day. And there was a lot of celebration going on that day, Richard.
Yeah, I mean, look, there was a lot of disbelief until it actually was entered, and I think one of the reasons why, was there was just some concern because it was such a high-profile case. Would a conversation happen? Are you kidding? This case related to one of the marquee cases this office has brought. We're just going to walk, and so there was, everyone's breath was held. My attorney's, mine, family, friends, until it actually went through, and that was. In many respects, I want to say it was a kind of divine intervention, because it had obviously been something I had been dreaming about for many, many years. And it didn't turn out exactly the way I wanted, but at least from a perspective of, and I really do feel this way, that God gave a chance for me to try to fix things as best as I could, but it would not come without faith, because there was always a risk that the judge would deny the plea. I would go to sentencing and get incarceration because I had blown up the cooperation agreement. And that was always sort of looming in the background. And so I really do feel that if there's any act in I've lived a very blessed life. I fully admit that. But I really feel that was a kind of divine act. Um,
And and it feels like it was a very anticlimactic moment in a way, because it was just like the feather falling on the scale, and then nothing. But in truth, there was a lot of wreckage
oh, I
for
mean,
you and your family, and so why don't we kind of talk about that a little bit, and then we can talk about some lessons learned,
sure.
because I think that, I mean, certainly, for example, on our white collar support group, you became a folk hero overnight, but you were very generous with everybody to explain to them how difficult this had been, and how now your life, how difficult it is for you to re-engage your life, and how the opportunities that you had 7 years prior, they weren't rushing back at you to open their arms to you. In fact, you greeted with a lot of caution.
Um, you know, so that's exactly right. Um, it was a very it was a very challenging 7 years up until the having the plea vacated by the judge. And one of the reasons why it was so difficult, and I think this is something I cannot stress enough, I never felt like I could really talk about what had occurred in those 7 years with people, because I put on my cynic's hat, which is, how can I credibly explain to somebody um, that I pled to something that I hadn't done? It would just ring false. It would ring false, like there's a scene in The Shawshank Redemption where Andy Dufresne asks another inmate at the Shawshank prison, "What'd you do to get in here?" And he says, "I'm innocent, lawyer fucked me." Pardon my language. But I felt in the back of my mind that that's how I would come across to anybody I tried to explain this to. So I didn't really put myself out there in terms of seeking tangible employment opportunities or looking at new things to do. I was candidly a bit of a hermit, and I regret that. Um, Following the vacating of the plea, I would say, one, it's still a very hard conversation to have with people about what had occurred, because when we look at the facts at what happened, it's still very hard to understand. In fact, I sometimes still look at myself and I don't understand how I could have pled guilty. Um, in many respects, somebody can say, "Oh, it's very human. You're under a lot of trauma. Think about the emotional duress." And at the same time, I know that I'm a logical person, that I try to form a mosaic around facts, and I can't understand why I did that. So, and the reality is, in terms of tangible opportunities ahead of me, I mean, there's always going to be this smoke or this confusion over what really happened, right?
Yeah.
And I have to be honest. It's not that I have, been searching for a lot of opportunities yet. I've started to, and I don't know what those conversations are going to look like. So, when we talk about the white collar support group, which I think of as divided into two groups of people who are in the process of going away, in the process of getting sentenced. They're still in the midst of their legal case, and they're still suffering from trauma. Their world is spinning around them. And then there are those on the other side. It's a part of their history. It's behind them, but they're still struggling to with reentry, or trying to find meaningful work, or their relationships, or so on. And in many respects, their world is still spinning around them.
Of course.
And I am in that group. Regardless of whether I went away or not, or whether I have a felony, which I don't. I still have that shared experience with folks, and I'm still trying to figure it out.
Mm-hmm. So let's go to some of the lessons learned here. All right. So we were talking about lessons learned.
Yes. Look, I think that there are so many lessons on many different aspects of the case. I think, the biggest lesson that I've learned is, I've replayed this in my mind so many times in terms of how this could have ended up differently. And there's a few key things that I obviously should have done. The first is, there is a bubble that is formed around you immediately once the investigation occurs, because your attorney advises you that you cannot speak about it with anybody other than your wife. And there's a good legal reason for that, which is anybody can get subpoenaed except your wife, who is subject to something called spousal privilege.
Right.
Now, let's think pragmatically. Practically speaking, if I talked about this with my parents, could they have subpoenaed my parents? Maybe. But they wouldn't have, practically speaking. And I think it's important to seek counsel from people who have your best interests at heart. So whether it's a therapist or a few trusted friends who are not involved in your case whatsoever, and therefore have nothing helpful to offer the government, parents or siblings, I just think that's really important to have a right network around you. If you're religious, a spiritual advisor, somebody that's giving you guidance. And one thing I will say, and it's actually important for me to mention this. When I had Greg Morvillo as my attorney, he also had an of-counsel named Savannah Stevenson, who she now is in corporate law, but she was an Episcopal priest. And I also had Jeff Grant, who is a minister. And I really sought to try to make a decision which was based on what I felt was objectively the right thing to do, not just based on sort of schematics and scenario planning in terms of legal outcomes. And that's a really important thing to keep in mind, because you don't want to lose sense of who you are. I lost a sense of who I was because I got up in front of a judge and pled to something that I didn't believe I had done. And very much so, right? And I had surrendered myself to the cynicism of the system. I surrendered myself to the cynicism of former prosecutors who, and really sort of surrendered, again, and I said this before, surrendered my agency to my advisors. And the reality is, you can never surrender your agency to your attorneys. So that's one thing. The second thing is, you really need to do better. One has to do much better diligence on finding an attorney who is not just attending to the specific criminal case and projecting their own opinions about that, but understands holistically what is somebody going through when they go through this process, because the attorney needs to make sure that the client is in the right state of mind to be able to make decisions appropriately. It's really a shame, Jeff, that you were not an attorney at that time, because how did I find an attorney? I just Googled. I Googled articles about people involved in insider trading, and I cold called attorneys. The attorney I found at that time, I found off of his profile. I got his number off of his profile page on his website.
Sure.
And, I had no way to evaluate, what was happening. But I do believe that had somebody, said to me, take a step back. What's your state of mind? Calm down, breathe, make sure you're getting a good night's sleep before sort of the legal machinations. That would have made, a world of difference. Mm-hmm. So we know now that the facts would have made the case go away from the onset. And the decision to not approach SAC was, a tremendously bad one, because how can you plead to a corporate case, a securities fraud case, without the benefit of even having the primary information? I think there's a separate question as to how can the government accept a plea without having the absence of that information either, but that's, a discussion for another time. So,
Rich, I just want to be clear here that one of my trusted advisors has said to me that the most important decision that you can make in life is who you choose to marry. Yes. The second most important decision you can make in life is who you choose to be your lawyer if you get indicted. And your case really embodied that because again, it's impossible to blame you because you were in trauma at the time.
No, I should be blamed for it. I mean, I have to take responsibility for the decision I made. I was not in a good state of mind to pick the attorney. And one thing that I absolutely should have done, I should have brought my wife to New York when I was interviewing with these attorneys to get her sense as to the character of the attorneys and what the selection would have been. There was a very odd thing in my mind in terms of the way I think about what happened. I was feeling, as I mentioned, very bad about myself. Like what I had done in a cosmic sense to put me in this situation. Mm-hmm. I must have crossed somebody. Did I not? I don't know how to think about it, but was this?
Was it karmic? Was it karmic? Did you get what was coming to you?
Right. Was this a sense of cosmic retribution for what was occurring? Yeah. And I carried that with me to my meetings with attorneys, and it certainly influenced the rapport and the relationship I had with those attorneys. I think I wanted somebody to make me feel bad. I think I wanted somebody who said, "I have all the answers. Don't bother." Mm-hmm. That was a bad mistake. And I'm sure had I brought my wife with me to meet with these, she would have flagged that because she wasn't thinking that way. She just wanted, the best outcome for me. She was terrified. She didn't, understand the American system at all. But, she knows people. And I think that would have made a world of difference. So that was another error on my part.
What wasn't such a big issue in your case, but of course we know is the case with a lot of our of people going through this, is the budget and the competing interests and the competition for the dollars.
Yes.
So there's you only have a certain amount of money that you have available or that you can spend, and if the lawyers are competing against the forensic experts, or competing against the accountants, or competing against all of this for the same pot of money, somebody has to be the safeguard. Somebody has to be the paymaster to make sure that the funds are being spent in the way that's most beneficial to the client. And that's a hard thing to do when you're the client, if you have no perspective and no experience in these things at all.
Look, you actually hit on a point which I think just occurred to me, and I think that's exactly right. The dynamic is you're getting these bills when you're the client, you're paying them, and you really don't feel like you can push back on any of those, because what if that affects the quality of the advice that you're getting? What if your defense attorney has a card to play and he's just not going to play it for you because he's upset that you are arguing over an item on the bill? So, the idea of having a third party, somebody who's there who is evaluating these things, makes complete sense to me, because it really is an awkward position for the client to be in that situation where they're trying to get the best outcome for themselves, the best advice, yet at the same time, that's sort of counter to the idea that you're also trying to make sure that the legal dollars are being spent wisely. So it's certainly, I early on, I wasn't in any situation to try to, and I didn't make any argument about the legal budget. And look, candidly, more than half of it was spent on a review of my Google emails, of which less than a fraction of 1% were related to work. And resulted in over half of the legal budget that was spent up until the time I switched attorneys. I mean, when you think about it, that doesn't make any sense whatsoever, right? Because you were only going to get not even a limited insight into your business activities. Really, there should have just been an insistence to push those aside and let's get the real emails and let's get his actual work IMs. Again, so much is so obvious in 2020 hindsight, but
just to be clear, especially to the people who'll be watching this, who are maybe business students or law students, or people who are going through the throes of these issues themselves.
Yes.
a small fortune is spent reviewing documents
Yes.
and emails, but none of them are the documents about the transaction itself on the day it happened.
Yes.
So that would be tantamount, for example, to being hit by a car and going to a personal injury attorney, and they're reviewing everything other than the moment you were hit by the car.
Yeah, that's right. And I think that was known in my case. It was rather in the context of this quote unquote cooperation, where you're coming forth with anything whatsoever that could be helpful to the prosecutors. And so it has to do with, gosh, did you cross the line anywhere else? What else is there, is there in your emails that we can use against you ultimately, which, is an ironic, sort of turn of events. But yeah, that was the dynamic.
I find it so interesting because in my background, this, that I was general counsel to some large family-owned real estate companies. And one of them was indicted, and there was a seizure, and all of their records were seized. And so not only were the companies indicted, but many of the senior management and owners were indicted. And I was general counsel to the firm. I came in after, and I was the paymaster. So there were dozens of criminal defense attorneys who I wasn't the criminal defense attorney, but they had to explain everything. And so there was a big context, and they had to submit their bills to me. Mm-hmm. And they didn't get paid until they were approved. And I wanted, before I approved any bills, because my client was the one paying the bills, I had to understand how that fit into the entire strategy. It was much more efficient than had they just been submitting their bills to my client, who was wealthy, but was shell-shocked the same way you were. There's no way he could have figured it all out. So I think that that's a very important role that not too many people take advantage of.
Look, I completely agree with you. I mean, the reality was these were things that I, at least in the first phase prior to the guilty plea, I'm just not even thinking about that type of thing, right? Because it would have been great to have had somebody to think about that type of stuff, because I certainly wasn't. Nor did I feel like I could, because of the awkward position I felt that it might put me in vis-a-vis my defense attorneys.
Sure. What other takeaways or lessons learned do you think that you had here?
Well, I mean, I haven't spoken much about the case. I do have a pretty strong opinion about the motivations of the actors involved, the prosecutors, the defense attorneys, myself, sort of the way that it's been spun in terms of the narrative for the media. I've even thought about the FBI agents. A very curious thing happened about a year after I pled, which is that the FBI agents who were assigned to my case began to rotate off and transfer to different parts of the FBI. And the last one to transfer off of my case was a very nice guy who had been very nice to me, through my arraignment and through the entire process. And he called me up and he said, Richard, I just want to apologize for everything that happened to you. And I was like, what are you talking about? What do you mean? He's like, none of the stuff that I just didn't think that it would, things would have turned out the way they did when we first approached you on the street. And I was like, what are you talking about, man? And then I think he realized he said a bit too much, and he's like, anyway, I've got to go. I wish you the best. And I've never spoken to him since. I now feel very much so that in hindsight, this is after new evidence came to light, and he was aware of it, but I wasn't, that I think he maybe felt a bit guilty about what had occurred, because I think he understood that there was a strong argument that what I had asserted the entire time was true. I guess the one thing that I realize is that everybody has their own motivations, and it's important to always keep that in mind. the prosecutor may get to, for a period of his time, represent the United States versus, but he is also thinking about what's next for him in life, whether it's a political position or a more well-paying job doing white-collar defense at a firm. There is an entire, as you say, Jeff, ecosystem of people who have motivations of which you are largely transactional in that process. And I think it's really important to sort of I think it's just important to know that as you're going through it, because that attorney that you are with or those prosecutors are only walking with you for a very short period of time, and then they move on. So and they know that, and I think that's something else to sort of keep in mind.
Well, if you weren't the one going through it, if you were the negotiator or you were doing it for a customer or client, then you would understand, or it would be your job to understand what the agenda was or the motivation of all the various players at the table, and that calculus you'd be able to do all throughout the process. But it's impossible to do when it's you and your family in their sights. It's impossible.
Yeah, I mean, and also, look, I mean, I don't know if this is because I grew up in the Midwest. Sometimes I believe that I'm more naive than others. But the way I grew up, those are the good guys. They're out for truth. They're out for justice. They're not out for themselves. And I think that that's something that I didn't really understand was not necessarily the case until, unfortunately, my own case. So, yeah, I don't know what to say. And look, and that's not to say that people in this situation, everybody has these ulterior hidden agendas. That's certainly not to say that at all, because I do know some people who've gone through these cases and felt that they were treated very fairly. They have no sense of bitterness about what occurred. They recognize they did something wrong and they accepted responsibility for it and have moved on with their lives. But I just think that the possibility of it is there, and it's something that people should be aware of.
Richard, I'm a huge admirer of yours, and I have been all along. But even to rip open this wound and talk about it, and do it really for the benefit of other people, mostly. And I'm sure that you're looking for some form of closure, but you don't need to go through all of this in order to get closure. So I think this is a hugely generous act on your part.
No, thank you for the opportunity. You're right, Jeff. It's not, I'm generally very reticent about this. I can't imagine I'd do something like this in the future, but I would like to at least insert the question with respect to the narrative that's been put out there and advanced by so much media about what happened, not just with myself, but the larger case and this era in time. And so I'm glad to have the opportunity to at least raise a question regarding that.
So, Richard, thank you for coming on this podcast, and we'll have some show notes that with some of your background and some contact information if people want to get in touch with you. And God bless you and your family, and I hope to see you all soon.
You as well. Thank you, Jeff.
Thanks. Thank you for joining us on White Collar Week, sponsored by Progressive Prison Ministries. You can learn more about us on our website, prisonist.org. That's prisonist, like feminist. And please remember to rate, review, and share this podcast so that families suffering in silence can find us if they need us. See you next time.